Your Honors. The Fourth Amendment does not assure a defendant that no government search of his house unless he consents. Rather, it guarantees only no such search will occur that is unreasonable.
Well, what the obvious implication is that when he doesn't consent, it is unreasonable to search. That's the very point we're making here.
However,
or your counsel is making.
However, we have an authorized co-tenant making a consent that was given intelligently, knowingly, and voluntarily.
Well, when you say knowingly, there's no evidence that she knew that her husband had refused consent, correct? You would agree with
yes,
that?
The facts are uncertain as to
and
that.
doesn't this encourage police officers to play games, to find ways around the Fourth Amendment's very strict requirements? Hey, he didn't consent. If we go over there, we might find someone who will. Let's see what we can do to vitiate the consent.
No, not necessarily, because the Fourth Amendment merely states that we have three requirements to give consent. The police officers do not have to inform the person who's giving the consent of the right to refuse the consent to the search, nor that an objection to a search has been made. The only thing that they have to show is that the consent was not a product of coercion or duress.
Yeah, but you're looking at it in a vacuum is what we're suggesting. We have to look at the whole gestalt. How did this come out? They went with the guy that they arrested. This just, courts are here. You can look at the strict language. The courts are here to give a reasonable interpretation to the statute and to affect its, and the Constitution, and to affect its means. Are we not depreciating the very concept of privacy that's so important?
Absolutely not. The current case that's controlling this issue is Georgia v. Randolph, which I would like to discuss. In Georgia v. Randolph, we held that a warrantless search was unreasonable as to a defendant who was, one, physically present, and two, expressly refused to consent, which subsequently consent was given by a co-tenant.
Let me ask you this. If the police in Georgia versus Randolph, the defendant says no at the front door, wife says yes, and the police know that Georgia versus Randolph says, is going to say that's not good enough. And the police just take the defendant down to the police station and then go back to the wife and say, well, he's not here objecting on the property. What do you say now? Do you still say yes? Are they allowed to get in that situation?
Well, those facts are a little bit different than our case at issue.
I know, but what is your position on what the answer would be in that scenario?
Well, it is uncertain. I would say that if he did expressly object in the face of the consentor, then that's a different situation. The outcome may be different.
Okay,
However,
so what you're saying is that if by the happenstance that he happens to make his first objection at the front door, then any further consent from the wife doesn't matter. But if the first time he says no isn't at the front door, but is at the police station, then it's okay. I mean, how is that not beginning to make the Fourth Amendment turn on just random happenstance?
well, currently, I believe those facts are similar to People v. Fernandez, where in People v. Fernandez, he expressly objected to a search, was taken to jail. The girlfriend consented to a search of the home where evidence was seized. Currently, that search is considered to be valid.
Do you think when the police went to the premises here, they did inform the wife that he was under arrest, right?
Yes, they did.
Do you think they should have told her he didn't consent? Don't you think she should have full command of the facts?
Well, there's nothing in the Fourth Amendment that says that they have to inform her of any objection to
Well,
the
no,
search.
I understand that. You're saying the Fourth Amendment can't contemplate every single factual scenario that's going to occur. We have to interpret it in the light of reasonable facts. And so, don't you think it's if the police may have said, he said we can't consent, or he didn't consent to the search of the property, that indeed could have had a profound effect on his wife's reasons to give consent or not give consent.
Well, I believe
You
that
would agree with that, would you?
Well, I actually believe that it's irrelevant because she's authorized to give consent.
But she's authorized with not a full understanding of what all the facts are.
She was informed that her husband was arrested and he
Not
was a
that he
suspect.
didn't consent.
Exactly, Your Honor.
And in Georgia, the Georgia case, they were both there, right? I mean, the party that consented knew what the other party had not consented, right? Am I right about that?
Exactly, Your Honor. That's believe that that case doesn't apply here because in this case, the appellant was not physically present. There was no express objection in the face of the authorized co-tenant who was allowing the police to come in to search the home.
But she's operating under a deficit of factual knowledge.
However, she consented orally and in writing. So she intelligently, voluntarily, knowingly knew what the police were there to search for. The search, she didn't limit the scope of the search. The search was in a common area of the home. There was no wall that was dividing this room, whether this was a private bedroom or not. They merely walked into the home, walked into a common area of the home, and seized evidence that they believed was relevant to the robberies in this case. I believe that her oral consent and in writing evidences that his refusal does not trump.
You know, I'm sorry, does not trump the Fourth Amendment.
Yeah, does not trump her consent.
Or consent. Okay, now, the room that they searched, there was a sign on it, there was some indication, hey, this is Roe's room. And Roe told them, you do not get the consent, I'm not giving you consent. So she let them into the house, but here's Roe's room now, at the risk of sounding sexist. There's a bunch of posters on the wall about football or Raiders and so on, that might not necessarily be an indication that that's his room as opposed to his wife's room, though there are many women who are avid football fans. My wife isn't one of them, but I do know that there are many that are. So wouldn't that be an indication, hey, it's more likely than not this is his room, and he said, you can't go in this room?
Not necessarily, Your Honor. The wooden carving that said Roe's room, they both share the same name. They're married. So it's uncertain as to whether,
May I ask,
yes.
what are we trying to establish? Consent, he's close, he's so far, he's here, he's there, she says no, he says yes, she says up, down. What is the objective of all of this dance that we're doing? What are we trying to establish?
That her consent was valid,
No, something more than that.
Deeper.
that the warrantless search was valid due to the
Was-
consent.
It's a reasonable search. That's what the
Reasonable search.
Constitution's asking, says, is it reasonable? We have a moving target going on here. The police officer is supposed to operate under certain rules. People are supposed to have certain expectations of privacy. This is like nailing Jello to a wall. It just keeps sliding all over the place. There's another rule that tells me how I can make it a reasonable search. What would that be? Guaranteed reasonable.
Okay,
And it's found right in the Fourth Amendment. What do you think that might be?
well, what I have for the
Go towards the end of the alphabet.
Well, what I have for the Fourth Amendment is that the Fourth Amendment does not assure defendant no government search of his house unless he consents, but rather guarantees only no such search will occur that is
But
unreasonable.
there's
But
two
reason-
exceptions to the Fourth Amendment, or two ways to comply. You can get consent, or you can go get a.
Warrant.
Yes.
Okay.
Now,
W.
all the information they had here, is there any doubt as a public prosecutor representing the people of the state of California, they did not have sufficient information that a reasonable jurist would have issued a search warrant?
Absolutely a search warrant.
Then why didn't they get one? And that solves all this nonsense that we're going through about how voluntary and how willfully. Why are we doing this dance? We're protecting privacy. We get rid of that because this Fourth Amendment tells us exactly what to do. Go get a warrant.
Well, the facts are uncertain as to why the detective didn't go and get a search warrant before he went to the wife's home.
So now the facts are uncertain. We might not get a warrant. We don't have enough information to get a warrant. If that's the case, do we want police officers acting in that fashion? Let's try to get around the Fourth Amendment by seeking a warrant, and instead we'll go and see if we can get consent from somebody else.
Well,
That, doesn't that leave that? I mean, even as a prosecutor, I know you want to win the case. That leaves a bad taste in our mouth, doesn't it? Certainly does in mine. I'm telling you right up front.
Well, Your Honor, I believe that regardless whether we had that evidence or not, this would constitute a harmless error, as we have probative evidence from all three witnesses that identified the suspect as
You're
the
dancing,
robber.
you're doing a dance here. Let's go back to the issue. You may be able to prove the heck out of this case, but the question is whether or not you've used the evidence, you want the evidence, you got the evidence, and we're sitting here to say,
most courts would grant a warrant in this case. The guy had a gun, he had this and that. Where did they hide it? Could be in the house.
Absolutely. However, the facts are unclear as to why the detective did not get a search warrant.
Yeah, they're unclear because maybe they, who knows? Maybe they're lazy. Maybe they'll learn a lesson from this. Okay. If the defendant you're saying this case is not like Georgia, right?
Yes, Your Honor.
And it's not like Georgia because,
The defendant was not physically present, and there was no express objection to the search in the face of the co-tenant who was consenting.
is that a distinction that's meaningful?
Absolutely.
Why?
Absolutely. Because if you have two people who are co-tenants, both are authorized to give consent to search their home. One is saying no, and one is saying yes. There is a discrepancy there. We cannot, that would open up the floodgates. We can't allow such a thing. However, if one isn't aware that there's been an objection, and someone wants to come into their home to search, why should we not let them enter?
But shouldn't the police know it? So, I'm just gonna throw this out as maybe, shouldn't the police tell her everything? Not only that he's been arrested, but that he hasn't consented to the search?
Perhaps.
Perhaps. Well, wouldn't that make all the difference in the world? That would
It
make
may.
that would, now we're getting closer to Georgia.
It may, however, those facts aren't present in this case.
I know they're not present, but I'm saying, maybe the police should have done that. Maybe that's a factor that should go into our decision. Tell me, what do you want to, or anything else you'd like to say about this issue?
Yes, I'd also like to say, again, that if the trial court's error violates the Constitution, that this would constitute a harmless error. As stated in Chapman versus California, the standard is to prove beyond a reasonable doubt that the error did not contribute to the verdict obtained. Here, the state, we presented probative evidence that the witness testimony of all three victims identifying the appellants at trial. Additionally, there was a six-pack, a photographic lineup, where the two victims had both circled the appellant as the perpetrator, as the robber. And so I believe that even if this evidence were to be suppressed, that the outcome would be the same, Your Honor.
What's your view on the habitability of the lobby?
Well, currently California case law in People versus Wilson states that a hotel lobby in fact constitutes first-degree robbery, as it is an integral part of an inhabited dwelling. A robbery of an inhabited dwelling or any inhabited portion of that building constitutes first-degree robbery. There is an expectation of privacy there. This hotel lobby had a kitchen. It had an office. The victim was actually in the kitchen when the robber entered the hotel lobby.
Isn't this like any commercial establishment?
No, it isn't, because people sleep there.
Well, they don't sleep in the lobby unless they're homeless and they get thrown out.
They don't, but it's an integral part of that inhabited dwelling.
Lobbies, it depends on the hotel, I guess, but I've been in some pretty fancy hotels. You go to another city like New York, and you stop in a lobby, there's shops there, you can use a restroom, you can sit and relax, you can have a drink, you can have lunch even. Is that really part of the apartments in the hotel?
Well, that's a little bit different. Here, the lobby was only, I believe, between 25 and 30 feet away, the first hotel room.
So we can make a distinction between fancy hotels with big lobbies and shops as opposed to more modest hotels with
Well,
small lobbies.
I believe that's relevant as to, is it an integral part of that inhabited dwelling?
How do you
The
think, what do you feel about garages? What do you think about garages attached to the house?
Absolutely. There's absolutely an expectation of privacy there. We keep our personal belongings there, we keep our vehicles in there, we keep refrigerators in there, we keep our possessions in there. So absolutely, that's first-degree robbery. That's an inhabited portion of the dwelling.
So you also believe that privacy is relevant to this question?
Well, that, what I believe is that this is an inhabited dwelling, and that is an integral part to this. The close proximity of the rooms to the lobby, the kitchen in the lobby, these are all factors as to, there is a certain level of privacy in there.
Yeah, multi-use condominiums that are running around these days. The first tier is commercial establishments, then the second tier is apartments, and the third tier are purchased residences. How do we grade this integrated building in terms of the nature of the premises for purposes of whether it's a first or second degree robbery?
That's an interesting question. I believe when you have a business at the bottom of residences that are built on top of them, it's different because there's a different expectation of privacy down there. Those are businesses. The inhabited dwelling is not a part of the business. There's a separate entrance to get to those, to get to the residence. So I believe that would be a different outcome as far as first degree robbery or not.
Is not the purpose for which this statute is designed really addressed to the nature of privacy in this sense? When you go into an apartment or a home or a dwelling, the walls are there, it's an isolated area where the robbery is less likely to be discovered, less likely to, as it's being perpetrated, be interrupted, where the assailant gains a sense of security and majesty within those confines. If you accept that premise, then what has that to do with a lobby that people are passing in and out of on a routine basis, and the door's unlocked and it's open and accessible to the public?
Right. I don't believe that, I believe a hotel hallway and a hotel lobby are one and the same. People are coming in and out, people are coming in and out of the hallways as well. And these are all integral parts of that dwelling.
But once you get behind the door of the apartment and that door closes, it's a qualitatively different environment than it is in the hallway or the lobby. Behind that door, detection is difficult, if not impossible. The people inside are more in terror and in fear and in danger by being there, as distinguished from those open and public places. Isn't that really what they're driving at in differentiating between the robbery perpetrated in an inhabited dwelling versus a standard robbery of the second degree?
I agree with that, Your Honor. However, currently our California case law just simply states that a hotel lobby is first degree
But
robbery.
I understand that, but we're on an equal court, we're not bound by that precedent, and we can certainly take another point of view.
Doesn't that precedent sort of set up a spectrum? And at the one end, I think, it would be a robbery affected in the middle of Disneyland, out in the public or public square or park. And then you have at the other end, perhaps, a robbery committed in a mountain cabin where there's nobody else around. And then you have all the things in between. And so you can have the hotel room, you can have the hallway of the hotel, you can have the lobby of the hotel. And is it really what we're trying to figure out here is where to draw that line?
Absolutely.
And what you're saying is we should draw the line, so that the hotel lobby is on the same side of the line as the apartment building, not on the same side of the line as the public park.
Absolutely, Your Honor.
Your answer to that question could help him on a case he's working on right now.
Now, just for informational purposes here, just for the fun of it, as a practical matter, what difference does it make in outcome as to whether or not it's a residential robbery or it's just a plain old fashioned robbery?
Well, it's first degree or second degree
The
robbery.
difference is, I think, in the real world, the difference would be 1 year. We're talking about a prison sentence. That's all this is about. Guilty of robbery, either way. So we're talking about 1 year.
That's not the issue, though, that you might be interested in.
Well, the reason I mentioned that is we're doing all this dance. Again, I hesitate to use the word dance, but we have to identify a guiding light that gives us a reason why we're doing things. And I'm having a hard time discerning how that open
believe the line can be drawn for that. And I think it should be based on how close are the rooms? Is there a kitchen? Is there a lot of people that come into this lobby? I believe those are factors.
That takes me back to Justice Perrin's very incisive point about what goes on behind the closed door, locked doors, a sense of privacy, security, no matter how small or big the lobby is. That's something we have to wrestle with. How would we write that? How would we make that distinction?
Well, this was a small hotel. It was a small lobby. Only one person was working in that lobby. There was one front desk clerk, one kitchen, one office. Not many people come in and out of there. There weren't other people in the lobby at the time that this robbery occurred. So I believe that those are all factors to consider.
Okay, thank you.
2 minutes of rebuttal.
And we'll hear a couple of minutes of rebuttal. Thank you.
Like my opponent said, there are certain factors we should take into account when deciding whether or not the lobby isn't inhabited. The first issue is they all have security cameras. Last that I checked, hotel rooms or residences don't have security cameras inside the rooms.
One would hope not.
Well, won't go now, exactly, unless, you have a nice house and you want to, take care of your. The other issue is the perpetrator came through the kitchen on the October 23rd robbery and robbed the clerk in the front of the lobby. He did not come through the lobby front door. So therefore, if he's come through the kitchen door, if a person who's going to rob a place comes through a door not from the entrance, is there really an expectation of privacy in the lobby for the clerk? If he doesn't come through the lobby door where you can see him, he came up and basically surprised
Well,
him.
maybe that would support her point, the prosecution's point of view. It's a more private place where he came.
Well, if it was a private place, I would assume that the kitchen door would be locked to the outside.
Not necessarily, but it's an area, if it's a kitchen door, how many people are going to be in the kitchen? Is this a kitchen for residents or a kitchen for a chef or what?
Well, I would assume it would be room service for the hotel, so a chef and maybe some waiters.
That's certainly not an area open to the public,
It is.
as opposed to the general lobby where you sit down.
That is correct, Justice
Yeah.
Gilbert. Okay. Let me
I'll
diverse.
let you go a little longer, just a few minutes, because we're asking questions.
To that point, there's no access to the public from the hotel lobby. There might be a locked door there, but from our facts, there was access to the outside. The perpetrator, my client, opened the door from the outside parking lot and walked through. And I think that's a very distinguishing factor in the case. He walked through the kitchen and robbed the clerk at the lobby door.
Okay.
My second point is going back to People v. Fernandez with the Fourth Amendment. My opponent says it's different from Gilbert in the sense that he left the property, but it's the exact same in the sense he objected when he was present at the property in front of his girlfriend. And this is the issue, that this creates a big slippery slope, because now the police can say, we're arresting you, we're taking you away from the property, and all of a sudden your objection is gone, even though he satisfied the factors, as my opponent said, under Randolph, physically present and expressly object. He did both those. He was just taken away from the property, and that's the reason why I think the court shouldn't rely on the holding of Fernandez, is because they have taken Randolph's holding and kind of mishmashed it and said, this is the same thing, while it really isn't.
Okay, thank you. No, I was applauding. Okay, we're going to take a brief recess and confer. We will return shortly